Hello and welcome to the Rodgers Brief for November 2nd, 2024. I'm Adam Rodgers. Thank you for watching and thank you for listening. It's been a little while since I've done one of these longer form videos of the Rodgers Brief where I talk about the legal issues of the day, stories in the news that are either underappreciated or misunderstood, or just I find something interesting about them that I think you'll also find interesting. So it's been really since the summer since I've put together one of these shows, but I'm going to start doing these again more regularly and hopefully bring you some interesting stories. What prompted this week was a special report that came down with commissioned by the Nova Scotia Barristers Society from respected lawyer Douglas Ruck, who was talking about systemic racism at the Barristers Society and in the legal profession in Nova Scotia more broadly, and delivered about a 50-page report this week with some publicity. So I dove into that report a little bit this week, and I want to bring you some thoughts from that. But there's a couple of other things that came on. First, the Nova Scotia election is on now, provincial election, and so I'm going to go through the provincial party platforms of the three main parties for any justice issues that they are trying to raise in their campaigns. And then two national stories. One deals with medical assistance in dying, and there's two aspects of it. One out of British Columbia, where there was an injunction filed to prevent one specific attempt to use MAiD. And the other is in Quebec, where the provincial government is allowing some adaptations, I guess, to the standard practice to allow advance requests. And this is not something that's been sanctioned nationally or through the criminal code or otherwise, but they're going to be doing it in Quebec. So I want to talk a little bit about that. And the last thing is also a national story, and this is the Special Interlocutor. Kimberly Murray delivered a report this week on residential schools, unmarked graves, and in particular, one thing that caught the attention of lawyers, people interested in these kind of issues, free speech issues, was the obligation, as she put it, for the government to criminalize residential school denialism. So I want to talk about that a little bit too. Before I get into those, just a couple of other notes. Every week you can still catch the Sunday night broadcast of Canadian Crime Weekly. And last week's episode, we talked a little bit about the next thing, this Fear Thy Neighbor documentary style show that's now out about the Portapique shootings. But last week's episode was got a lot of views on that, and so encourage you to check that out. And then you can watch live on YouTube. You can just watch, look for Canadian Crime Weekly or the Nighttime Podcast at 9:15 Sunday nights. Paul Palango, author of lots of books about the RCMP, and myself, and host Jordan Bonaparte. So that's one thing. And just on that Fear Thy Neighbor, so I did get a chance to watch the episode. It's hard to find. You have to know somebody who knows somebody to see it in Canada, because it's blocked. But it's on Investigation Discovery in the United States. It's episode 1 of season 11 of the show, Fear Thy Neighbor. Broadcast in Canada as well, but for some reason they're 2 seasons behind the US in this. So what they did was a recreation of the Portapique side of the shootings from Gabriel Wortman. Not terribly exploitative, more, as the title of the show indicates, thinking of the relationships among neighbors and that sort of thing. And in this case, so talking about how he was, became friends, but was also an intimidating figure in the community. The episode is called The Mayor. Anyway, so Jordan, Paul, and myself were all quoted in there as helping, I guess, tell the story of what took place there. So I'll be happy to see that when it comes to Canada and is more widely available to Canadians. But well done episode, actors portraying some live footage, like some actual footage used from some of the locations around Portapique as well. Interestingly, also used in there is a replica RCMP car, which is permitted. That is one of the exceptions to the new law, which otherwise prohibits the use of any replica RCMP decals or uniforms or anything like that. You can use it if you're using it in a television program or some sort of art project of some, well, television, film, that sort of thing. You're allowed to use them. So also in that episode, actually, they spent a lot of time pursuing, or they seem to adopt the police informant angle that has been portrayed or advocated by Paul Palango and others, which certainly had a lot of resonance with people. All right, so keep an eye out for that. The other news this week from the little bit of Desmond inquiry connection, inquiry counsel at the time, co-counsel, Shane Russell, soon thereafter, actually during the inquiry before the final report was issued, became Judge Shane Russell. Well, this week he has been elevated to the Supreme Court of Nova Scotia and is now Justice Shane Russell. So congratulations to Justice Russell there, and good for all of us, good person to have on the bench. All right, so let's go in a little bit of order here. I'll talk just quickly about the Nova Scotia election platforms because there's not a lot there, and then I want to get into the Douglas Ruck Report, and then I'll convert from there to the more national issues. So, Nova Scotia election called last week, and one thing I've noticed, talked about this last week on the Canadian Crime Weekly, the cell phone decisions from Justice Brothers in the Supreme Court of Nova Scotia, basically saying the Nova Scotia legislation on cell phone usage more or less means that you can't convict somebody of doing just about anything on a cell phone in a car, because in one of those cases, actually the woman in question had the police officer could see the phone, her thumb was on the screen, but the court said, well, that's still not proof according to the legislation, that she was quote-unquote using the phone. Okay, so the judge in that case noted that the Traffic Control Act, there's new legislation that's been passed by the legislature in Nova Scotia in 2018 but never proclaimed, which would update and cover off some of these other things that you would think are distracting of drivers and should be banned or regulated into law. So I'd be surprised if at some point one of the three parties didn't at least mention that, because it is a valid thing to mention as a part of a platform. Pretty scant in terms of platform items for any of the three parties in the justice field. The NDP has said that they will strengthen rent controls, reduce the amount that rents can increase, and ban fixed term leases. So that's about all they've said about justice issues. Haven't said anything about nobody's said anything about the Mass Casualty Commission recommendations or the upcoming police contract review in 2032. Any planning that may be taking place to replace the RCMP or change anything structurally about the policing in Nova Scotia, even though that was very much recommended by the Mass Casualty Commission. The Liberals mentioned lobster fishery, that they would appoint a royal commission. Interesting idea in its own way, bad idea, I think, and they would have what they call zero tolerance for any illegal lobster fishery. Well, all right, that is very simplistic. It does not seem, and they didn't mention in any way the take into account Indigenous rights or any sort of attempt or thought about balancing those with existing commercial fishery regulations and conditions and license holders, even though that is squarely the problem right now, or the issue that needs to be resolved, and that is creating all these problems at the wharves and on the water. So not much there. The governing PCs haven't mentioned anything about justice issues as of yet in any of the releases, and none of the three parties have what you would consider a quote-unquote party platform. Nothing comprehensive about any of the parties. It's like they didn't know there was an election coming. All right, so next thing, Nova Scotia is this the Ruck Report, released this week. And it was, the genesis of this is back the May 25th, 2020 murder of George Floyd in Minneapolis, Minnesota. And at the time, that wasn't it alone. I mean, there's obviously lots of protests arising from that in the Black Lives Matter crusade, as Mr. Ruck describes it. But there was a statement released by the Bar Society at the time, and the statement read as follows. Quote, "We acknowledge the existence of systemic discrimination in our justice system and the need for action and education to address it. We will continue our efforts to learn, to adapt, and improve our processes and to lead Nova Scotia's legal profession by example." Close quote. All right, so that didn't go over well with people, that quote from the Bar Society. Some people said, well, the Bar Society itself is racist in its own ways, and so anyway, that set off a procedure which led to Mr. Ruck being appointed to make this report. And as he puts it, it wasn't a report to determine whether there is systemic racism. It starts from the assumption or the presumption or the conclusion that systemic racism exists. It is assumed as a starting point. There was about over 200 people interviewed for the report by Mr. Ruck. And so anyway, and he has 21 recommendations at the end of it, including mandatory training and resources. He sees many of these recommendations as being first applicable internally to the Bar Society, but then applicable to the broader legal community. And among these recommendations are to review and modernize anti-discrimination policies and regulations. Okay, so I guess the first thing I see when I think of this, or when I read through the report, well-written report, sometimes, and this may have been part of the case with the Mass Casualty Commission too, part of the point of these reports is simply that they be read, all right? So in reading this report from Douglas Ruck, you get a deeper sense of what somebody in what he uses. It's a great little phrase. It's a new one in a way. He calls it from equity deserving communities. So what a lawyer from an equity deserving community might experience in their career with the Bar Society, within firms, within courts, and it's troubling. At one point, there's talks about in court being asked, they show up in court, they asked if they're the defendant or the accused, or in heated arguments being referred to in a derogatory manner and through racial slurs. And Douglas Ruck says, well, he doesn't go into great detail on those kinds of things, but says basically, I've been a lawyer myself for 47 years, he said, and although everybody's experiences are unique, there's so many commonalities to them. And it has the effect of, limiting career success. Outcomes in courts are better for white lawyers and defendants. That lawyers have left workplaces as a result of discrimination. It has an impact on mental health, as you know it would, and has led to people leaving the profession or leaving the province of Nova Scotia. So, okay, all good, and lots of good language, including an African Nova Scotian acknowledgement that we recognize that African Nova Scotians are a distinct people who form part of over 52 historical land-based communities whose histories, legacies, and contributions have enriched that part of Mi'kma'ki known as Nova Scotia for over 400 years. So there's lots of good language such as that. But here's, if I have an issue with the report, it is this. The mandate is listed on page 7 of the report as being to conduct an operational and regulatory review. All right. That's his mandate. However, he says, and it was specified that, quote, the reviewer will recommend how the society can change these areas or improve them to eliminate systemic discrimination. So operational and regulatory issues. But then Mr. Ruck says, the operational and regulatory aspects played a minor role in perpetuating systemic discrimination within the society. He said, instead, these attitudes and examples of systemic discrimination are prevalent throughout the legal profession. So it's attitudes and examples and conduct, not regulatory issues or operational issues. Okay, well, that seems like a bit of a problem in a sense, and that they did not originate within the Bar Society, but rather are prevalent within the legal profession and society. Well, yeah, of course they are. I guess that seems like an obvious point to make, but he makes the point. And so he says, a focus directed exclusively on operational and regulatory change can miss the mark. Okay, but that's your mandate. So that seems like it might be the focus. He also mentions, by the way, that an issue is these diversity, equity, inclusion, accessibility committees and programs seem to be losing support within different organizations over the past couple of years. So that's an issue. One of the most interesting parts of this report to me, so part of the genesis of this was a complaint was made about the George Floyd comment. As I understand, the complaint, I don't know if it wasn't from Lyle Howe. I don't know if it was from Laura McCarthy, his wife, but it was related to the way the Bar Society handled the Lyle Howe prosecution, which I've criticized before. Well, Douglas Ruck talks about the history of systemic discrimination within the Bar Society, and he mentions two people. And the juxtaposition is not... anyway, there's some issues here. Donald Marshall Jr. is the first name he mentions. The second one is Lyle Howe. Donald Marshall Jr. wrongfully convicted and went to jail for 12 years. Came out, there was an inquiry into that. Bar Society did not participate. Okay, probably should have. A lot of good came out of that. So that was an example. Mr. Ruck correctly says about the Bar Society not being at the leading edge, the forefront of fighting discrimination. And then he gets to Lyle Howe. And I thought, well, what's he going to say? But he doesn't. He doesn't really say. He treads very lightly around the Lyle Howe question. I'm going to get to that. He doesn't say directly what he thinks about Lyle. But yeah, I'm going to go show some of the quotes from there. He does, so one of the main issues with Lyle Howe's prosecution was that he was prosecuted by an all-white panel. But there's a lot of hedging words here when Mr. Ruck talks about Lyle Howe. He said, the Lyle Howe case is a significant example of how systemic issues can impact access to justice for African Nova Scotians. It doesn't say did impact, can impact. Okay, Lyle Howe, a black lawyer, faced high-profile legal proceedings that raised concerns about racial bias in the justice system. Raised concerns isn't quite the same as saying raised legitimate concerns or unveiled concerns or, showed clearly that there were concerns. Okay, throughout the trial, concerns were raised about potential racial bias, both in the courtroom and media coverage. Many argued. Well, did they argue persuasively, successfully? No. Many argued that stereotypes and racial prejudices influenced the perception of Howe, potentially affecting the fairness of the trial. Well, did it affect it or didn't it? Potentially affecting. And then Lyle Howe matter serves as a reminder of the broader challenges faced by African Nova Scotians. Well, is it a reminder? Is it an example? Is it, a good example? He's not saying. In consideration of all particulars of the case, Okay, so presumably he's considered all particulars of the case and studied them. The question remains as to whether Lyle Howe received treatment that was different from the treatment white lawyers received in similar circumstances. So in other words, no opinion offered by Mr. Ruck about Lyle Howe's prosecution. So I thought that was interesting because I thought he would have had less trouble offering an opinion on that. He does, however, turn that he doesn't explicitly make this connection, but his main recommendation is that whenever there is a review whenever there's a disciplinary proceeding taking place and a person from an equity-deserving community is involved, they are entitled to have somebody else from their community present and involved in that, so there is a deeper understanding of the potential issues that might arise because of the race of the person being examined under disciplinary procedures. Okay, so I thought that was interesting. Anyway, some hedging going on there. I'd be curious to know what Lyle Howe thinks of the Ruck Report. I'm suspecting that will come out at some stage. All right, so that's good for that story for now. I'd be curious to see if other lawyers, what they think of the report and what organizations do with this report now, particularly the Bar Society. I mean, the Bar Society is supposed to be leading this effort now on. And one of the recommendations is that there be basically somebody to continue the work and be an ombuds, not an ombudsman, an ombudsperson for individuals from equity-deserving communities that are in these situations, so that there'll be more protections in place going forward for people under scrutiny. Something that Lyle Howe didn't have when he was going through his troubles. All right, let's go on then to national stories. The first one, I'll go next to the residential school questions. I think that's I just wanted to make a quick point on this. This is the Special Interlocutor on Unmarked Graves, Kimberly Murray, a respected lawyer, member of the Mohawk community, from what I understand. She gave her report this week. This was after a couple of years of work. And an interesting twist in the issuing of reports. Usually, like the Ruck Report, there's recommendations offered. Miss Murray does not give recommendations. She says these are obligations of the federal government. Government must do these certain things. One being a 20-year mandate for an organization to study the residential schools unmarked graves issues. The other is that Canada should refer itself to the International Criminal Court for a crime against humanity, for what took place in the residential school system. But most controversial, those are controversial enough, and I don't see, the 20-year mandate maybe, because this is going to be studied until it's clear. The self-referral to the International Criminal Court, I don't see that happening. I don't see a Canadian government, volunteering that our country committed a crime against humanity. I think that's probably a step beyond what any government will be willing to do. But the more the criminalizing of residential school denialism, similar to what is done in Germany and other European countries about Holocaust denial. Canada also has a Holocaust denial law brought in just recently in 2022, which has never been prosecuted. Nobody's ever used the legislation. These are very unlikely to survive charter challenges. So freedom of speech, as it has been applied in Canadian law, seems to me like it would, and I've seen other legal commentators support this as well, that it would overcome any kind of effort to keep people quiet, keep people's opinions silenced, or certainly to criminalize, varying opinions on the residential school system in our history. Now, the government was asked about this. Government Justice Minister Virani, try to parse this now. He says, quote, there is, quote, no desire to ignore any aspect of what she is suggesting. Okay. No, so let's underline a couple of those words, three of them. No desire. Okay, you may not desire to do it, but we're going to do it. No desire to ignore any aspect. Well, you don't have to ignore it. You can still not do anything about it. You cannot follow through on every single quote-unquote obligation. So they have no desire to ignore it. Okay, so they're going to at least read it. That's not ignoring it. Any aspect of what she is suggesting. Now, she very clearly said these are not suggestions, these are obligations. So for the Justice Minister then immediately characterize them as suggestions, I think is setting up a conflict right away. The other conflict is this. Okay, so 20-year mandate to study residential schools, unmarked graves issues. Okay? Studying something would seem to imply that you're going to learn something that you might have to resolve at some point, contradictory or evidence, or fill in the gaps where things are incomplete. All of these things, which seems to conflict at least a little bit with criminalizing residential school denialism, because that is set up to criminalize anything that minimizes, mischaracterizes, or attempts to attempts to deny that these impacts took place, that these deaths took place, that there's not children buried in these places that have not been studied with ground penetrating radar. Like, all these questions remain, and so on the one hand she says they need to be studied for 20 years. That's a long time to study something. On the other hand, we can't, everything that is thought, concluded, felt at any single point must be accepted and cannot be denied or minimized. Well, those two things don't meld well together. So I don't think that's going to fly. All right. Last issue is medical assistance in dying. There's two stories that came out this week. One out of British Columbia and one out of Quebec. The Quebec one they're both really interesting. So I'll start with the Quebec side of it, which is that they're going to allow, this is one of the problems the Supreme Court of Canada identified, which is if your condition is deteriorating and you have Alzheimer's, you have some physical condition, MS, that at some point you're going to lose your ability to consent. And so you want to consent now while you still can, thinking that in the future you're not going to be able to, and your life is just not going to be where you want it to be, and you're going to want to choose this path. But the law prevents that. Across Canada, you can't do that until you're in the position where the condition is irremediable, death is foreseeable, all of these, the guardrails are in place. In Quebec, they are now going to allow advance requests when the condition is likely to prevent them from being able to consent, just the complete solution of the problem. But it creates another problem because the criminal code applies across the country equally. And so all of these laws that are currently in place that prevent these advance requests are still going to be in place. So what happens? Well, in Quebec, the provincial prosecutors have been given direction from the provincial government. So the criminal law is federal and is directed by the federal government, but the justice system is administered and the prosecutions are administered by the provincial government. So the provincial government in Quebec is telling prosecutors, you will not prosecute these offenses. Unusual to do, but the federal government has said now they're not going to prevent it from happening. So an interesting experiment in a way to see how it goes in Quebec, and if that goes okay and if it doesn't seem to be being abused, then perhaps it'll expand to the rest of the country. Something to watch for. Now, abusing the MAiD system is exactly what was about to take place in British Columbia. So there was an application for an injunction to prevent somebody, a lady in British Columbia. She wasn't from British Columbia. She's 53 years old, flew in from one of the other Western provinces to British Columbia because she had been rejected for MAiD in her own province by her own doctors. So what did she do? She contacted this Dr. Ellen Wiebe, W-I-E-B-E, who is an advocate, an outspoken advocate for medical assistance in dying in British Columbia, and met this lady whose name is protected. Her her partner's name is protected. It doesn't say husband, spouse. Protected from publication so that they won't identify her or him or them. And so met the woman only over Zoom a couple of times. And what is her condition? It's a mental health condition. She has rapidly cycling bipolar 2 disorder and akathisia, which is associated with changing doses of psychotropic or antipsychotropic medication. Something which is temporary. And her family doctor said that this could be resolved in a couple of months once you get used to your new medication. And so, no problem, right? You get that and off you go. Well, instead she went to try to get medical assistance in dying in British Columbia, and her partner filed an injunction, and the injunction was granted by Justice Simon Koval, C-O-V-A-L, in British Columbia. So I think this Dr. Wiebe that's a problem. You can't just be granting, MAiD doctor for hire. You have to apply the standards, and this was clearly a case where the standards were not met, and so the injunction was proper. So anyway, we'll see what happens. I wouldn't be surprised if Dr. Wiebe is now going to be facing some trouble for her role in this, which was going beyond what doctors are supposed to be doing in MAiD situations. So lots to watch out for. All right, so those are the stories that I wanted to talk about this week. Glad to be back talking about legal issues with you. I'll be back, I think, next week. I'm going to keep this going on a regular basis at least, and so as long as you guys keep watching and keep an interest, then I'll still be here. So thanks again for watching, and thanks for listening, and we'll see you next time.